This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, we are joined by a fantastic trial lawyer and a good friend, Ed Ciarimboli out of Philly. How you doing, Ed?
I'm good, Michael. Thank you very much. And congratulations on your recent success. That was a outstanding verdict that you guys had in Texas. Great work.
Thank you. I really appreciate it. Before we get started, as always, I want to thank our sponsor, LawPods. You've seen the good work they've done. We're here recording live at the Academy of Truck Accident Attorneys Symposium in Atlanta. They've set up the lighting. They've got all this cool audio. All we have to do is talk. He goes back and mixes it, gets rid of the background noise, makes the clips to market it so people can actually watch and listen to this thing. LawPods makes my life so easy. If you want to do your own podcast, which I recommend, it's fun to do. It's a good way to get your name out there. I highly recommend LawPods.
Those guys are great. They, I have a face for radio, and they make me even look good sometimes. So.
Wow, that's hard to do.
It is.
I'm playing, my friend.
Yeah.
So we were going to talk about, you're one of the lawyers that actually tries cases.
Yes.
I think we were talking before, you've tried over 60 cases so far.
I think it's probably closer to about 100 since the beginning of my career, and it's interesting. I know you try a lot of cases, so that either means that you and I are very bad at settling cases,
selecting them,
right? Or selecting. Either we're bad at selecting cases or bad at settling cases. One of the two. But many years ago, one of my mentors, a guy named Paul Scopter, Paul said to me, he said, "Listen, I've never seen somebody as bad at settling cases as you are. You're terrible." He said, "You better get good at trying cases because you really are just terrible at mediations." And so yes, I've and I enjoy it as you do. I enjoy the process of being in the courtroom, the workup of the case, and certainly the theater of being in a courtroom in a live trial.
Yeah, and I think trying especially early in your career when you're building your skill set, I think trying the crappy case, I think it's important for a couple reasons. I mean, one, we get the repetition. So we're in there, we're getting the skills, so you have the comfort level when you go into the bigger one.
Well, I could tell you, do you remember your first trial?
I do remember my first trial.
Yeah, I remember my first trial. I represented a fraternity brother that had slipped and fallen in the shower of the fraternity the day that they were leaving for spring break. It was a new construction in this shower, and I remember getting handed the file and thinking to myself, "This is terrible. This is an absolutely terrible case." And then when I dug into it, I learned that the contractor had actually used wall tile on the floor, and it was super slippery.
Oh, wow.
Yeah. So it ended up, we were successful in it, but I remember walking in to pick that jury and the judge saying to me, "You're seriously going to try a drunk fraternity brother slipping and falling in the fraternity shower the day he's leaving for spring break?" I said, "Yeah, it doesn't sound that good on paper, but I'm telling you, Judge, it's going to go well." So what was your first trial?
Well, I guess my first one without a jury was one of our referring lawyers at the firm I went to work for as a baby lawyer. Mm-hmm. His aunt was buried in the family plot at what they believed to be a community cemetery. There was someone that had retired from the Border Patrol, found some old deed and say, "No, there's a cemetery corporation for one of my ancestors, and this cemetery is for the heirs, friends, and servants of Don so-and-so, and your aunt was not an heir, a friend, or a servant, and so you need to dig her up and put her in the pauper cemetery across the street."
Oh, my God.
And so it was really a trial over whether he could prove that whatever this weird cemetery corporation from 100 years ago that we couldn't even find evidence existed. but there was a deed. I mean, whether or
Right.
not he had the right to tell her to get out of, dig up your body and go somewhere else across the street. She's still there. We won the trial.
That's good.
And it was a really important lesson because I had like 4 arguments that I had.
Right.
And the judge at the end got up and said, well, you're wrong. All 4 of your arguments are wrong. But tell the other side, but you're wrong too, because these are the elements you have to prove: A, B, C, D. You didn't prove C or D, therefore, she stays there. And so I just learned, take the win any way you get it. You don't have to be right, just take it.
Absolutely.
But my next 3 were jury trials. They were personal injury cases, and they were defense verdicts. And I remember, a little disheartening.
I'm going to tell you something. It's not a defense verdict. You came in second.
I came in second.
That's all. You just came in second.
And because I remember, I'm a young lawyer trying to get a, real name with baby associate somewhere. And, some people started talking crap and talking smack, like, yeah, he's lost 3 in a row. This guy's no good. And then the 4th one, is not a huge case by our standards today, but we had $3,000 something in chiropractic bills, a girl that seemed just fine afterwards, minor collision, and we got $76,000.
That's awesome. That's great.
And, that changed everything because nobody else was getting $76,000 in those cases. And so then he just tried a bunch of tough cases, and sometimes we got the red ribbon, and sometimes we got an okay verdict. But like every 3rd case, we would get a verdict exceeding the policy limits on a case where they're offering $3,000, $5,000, and got a name for myself, and more importantly, just got comfortable in the courtroom. Just trying, back then I was doing 10 to 15 a year. Sometimes we would even pick 2 juries on, pick one jury in the morning, pick a different jury in the afternoon on Monday.
Right.
Try the first case starting Tuesday. Try that one Tuesday, Wednesday, get a verdict, then come back Thursday, Friday, get a verdict.
Yeah.
When you won both of them was awesome. Then I had a day where I did a criminal trial and a civil trial the same week. So I picked 2 juries on Monday. Then we came back and we tried most of the criminal trial, but the judge says, we'll come back at the end of the week. We'll do the closing because I got some other stuff to do.
Right.
So I did the civil trial, and I got a low, medical bills only verdict in the morning. And then I got a guilty on my client in the afternoon. I think I'm the only person I know that's got their butt kicked in trial twice, 2 different juries, same day.
Listen, I've had some stinging losses. I can't even say that I've ever experienced anything, along those lines.
Well, my client was on the roof. We tried self-defense, and people had threatened him, and he really did have a reason to be. He was a juvenile. He really did have reason to be scared. But instead of calling the cops, he dressed all in black, got on the roof, waited for them, and yelled, "Die, motherfucker, die!" and opened fire with a shotgun.
Not a good idea.
Thank God the gun jammed and he didn't kill anybody.
Right.
And look, they're all doing okay now.
Yeah,
the kids,
that's good.
They've gotten past that. They're adults, and I've heard actually from his girlfriend actually hired me on a case. He's doing a lot better now.
Good.
So
Good.
it makes me happy. But yes, those trials I didn't make money on them. Even the ones that I won, I didn't make that much money.
Sure.
But I got a bunch of trials, and now and I think it's the same for you. When we're in the courtroom on something substantial, we're not worried about how do you authenticate an exhibit, how do you ask the question, where do I stand, how do I move my body. I mean, you get you get more natural.
It is for me, walking to the courtroom now is just, it's such a rush. I love it. I love being in the courtroom because I have that body of work, and and they didn't all go perfectly, and witnesses faltered or things didn't come together as we thought they would, but now it's helped with preparation for sure for trial, and now when we walk into try a case, it's pretty airtight, and we have a good process, and it's ever evolving. I mean, obviously we're trying cases differently now than even 2 years ago or 3 years ago, and that's what I love. It just I really do think it's an art, and like yourself, I know you're always pushing the envelope, trying new things, and some of them work, some of them don't. But I think that's what really sets people like yourself apart from lawyers who say they try cases, or lawyers that do try cases, but they always say, well, this I've been doing it this way for 25 years.
Right.
Well, if you're doing it that way for 25 years, you've probably been doing it wrong in some capacity for 24 of those 25, because you're not learning and evolving.
Are things I learned, I had a kind of a system for trying car wreck cases that worked for, from 98 to 03 was working really well.
Sure.
And then it stopped working. Something changed culturally with the jurors in the community where I was trying them. And I had to say, well, I don't like the way these verdicts are training. I need to do something different. I need to go learn something different, try something different. I want to ask you something before we had something we were going to talk
Yeah.
about in this podcast,
Yeah.
but which is going to be, lessons we learned trying cases in COVID, and then how you've done that
Yeah.
to improve the way you're trying cases post-COVID. But before we go that, I want to talk about a mindset thing. And you've tried a lot of cases,
Mm-hmm.
you've had some incredible results, and you've had some results that probably aren't going on your website.
Yes.
So I think one thing that happens to people is they don't try cases because they have such a fear of not doing great. They have such a fear of losing or getting second place, however you want to put it, or, that looking bad, stumbling. How do you get past that so you can go in there and enjoy it?
Yeah, it's a great question. And I would say that 10 years ago, I probably would have been a far different answer. And 10 years ago, I would have said, I don't get over it. I'm
Right.
ruminating over it. And these things are, I'm really front and center in my mind. And, now, I meditate a lot. My wife owns a mindfulness company. So
wow.
that's been, a big part of that journey. Like just getting to a point that you're comfortable with yourself and realizing that, look, there are things that are in your control and things that are not. And for me, it was getting to that point that I'm going to work as hard as I can. I'm going to prepare as hard as I can. I'm going to go in there and do the absolute best that I can. But at the end of the day, 8 or 12 or 10 people are going to make a decision. And it could be on something that is completely unrelated to anything I did in the courtroom.
Yep.
Right. And so I can't control that. And I think once I got to that point where I had to feel comfortable in what I was doing, and whatever the result was the result.
Yeah.
And that was it. And so, now I look back on, cases that we've won and lost over the last couple of years. And I look at the process and I said, did we do that right? Did we do it? Did we go in there? And if I could say, yes, we did, whatever the result is the result. So
Yeah. And it's not that we don't learn from, okay, well, this didn't go well. I would like to do it. Like if I had tried over again, would I do it differently? Well, hell yeah, I didn't win.
Right.
Of course, why would I do the same
Right.
thing over again the same way?
Right.
But not letting it destroy you. Because I see some people like, well, this jury didn't like my tie, so I'm never going to wear a green tie. And I'm never going to do this and never do that. And jurors don't know. They don't know why. None of us really, most of the time, know why we decide things. We have an emotional decision, and then we come up with a rationalization for it. So we can drive ourselves nuts talking to the jurors afterwards.
And it's funny when you say talking to the jurors. So there was a judge in Philadelphia, Judge Jackson, and she retired a couple years ago. But I remember I tried a case, it did really well, really had a great result. And I said, do you mind if I talk to the jurors? And she said, don't talk to the jurors afterwards. And I said, why not? She said, because if they tell you that they just decided this case because they liked your tie or some reason, she said, you're going to have an obligation to come in and tell me, Judge, they didn't follow the law. She said, you can't control how they arrived at this decision. You can control what you did in the courtroom. You can control the evidence that you put in for the case. She said, but at the end of the day, she's like, don't talk to them after you lose and don't talk to them after you win. And I think it's a very instructive piece of advice because it could drive you nuts.
It can, and
it could drive you crazy.
I hear a lot of really smart people that say we should talk to them or hire someone to interview them. I used to. It drives me nuts. And we had a case, and I still think we made the right decision settling. We tried it for a week. At the end of the week, before the trial, they said they would never pay $1 million, and right before the trial, we will put $1 million on the table, but it's gone in 24 hours. So we tried it for a week, and we got an offer that was a multiple of that.
Right.
And the client was happy, I was happy, thought it was a great settlement, and we had tried a week of our case, but we hadn't tried, like our plaintiff hadn't gone on yet, which could have really turned against us.
Sure.
We'd made it's a brain injury case, the plaintiff looks kind of normal, and so then we went and talked to the jurors afterwards, and the defense lawyer asked me, well, how much were you all thinking about awarding? And all but one of them were between $10 and $15 million, which is way more than what we settled for. Now, but that doesn't mean that's where they would have been after my client testified, after the defense. But it was like, so the next time that Mallory and I tried a case, and again, we settled it actually I don't know how this ever happened. We somehow settled it for $1 million more than our demand the Friday before trial, like on Thursday. I mean, just everything went perfect in trial. It doesn't.
Yeah.
Sometimes you go to trial, you get your ass kicked. Sometimes like this, everything is working out. Everyone's freaking out.
You catch lightning in a bottle for sure.
And it was happening, and they saw it, and the excess people freaked out, and it got done. And so we were talking to the jurors afterwards. They wanted to talk to us, and then the defense lawyer was about to ask. I said, "I'm going to leave the room if you ask." I just told the jurors, like, "Don't tell me."
Yeah.
I said, "This is what happened to me last time. If you all were going to give a lot more than what I just settled for, I don't want to feel bad about it.
Yeah.
Like, I want to talk to you about what you thought about the client, what you thought about how we put things on." And then I learned, like, they hated watching video depots. Like, they said it was, like, painful. They said they paid attention, but it was so hard.
Yeah.
In that case, we had to do a lot of video because our client was an oil field worker, and all the witnesses were all over the country. And But, yeah, you can do a lot. You can learn a lot, but I also met lawyers that just drive themselves crazy because they're making changes based on the rationalizations for the not the reason.
And there is no rational basis.
It's emotional.
It's a very emotional thing, especially in a jury trial.
Yeah.
And you get 8 or 10, 12 people in a room together, and they're all going to have viewed that particular witness piece of evidence differently. And now there's going to be, horse trading on, numbers and everything else. So you just don't know. So I've kind of given into, look, I can control the process. I can control what we do. I can control the fact that we're going to focus group things and do data surveys and everything else, try to figure it all out. But at the end of the day, we may just not get it right, or we may get it right and not know why we got it right.
Yeah. So for our listeners that are struggling with this, like they want to try more cases, but they have that stress, they have that fear. What are some things that you would recommend for trying to improve the mindset of letting go of the outcome and, focusing on what you can control?
Yeah, I think one thing, that and everybody has to do whatever makes them feel comfortable in terms of, like, for me, it's certainly exercising. I know you're a big runner, and I think you have to feel good physically first, and then get yourself in a good headspace, whether it's meditation or yoga or whatever it is, because things that are going to let you develop skills so that you don't have to focus on the results all the time. You're focusing more on the process. And especially, doing a lot of meditation, and, Michael Leaserman, and I talk about it, just because he's a big meditator, and it's something that has helped calm my mind so that I'm not always oh my God, I got to worry about this and this and this and this and this. And so I think that my best advice to people would be, take care of yourself first.
Yep.
And if you take care of yourself first, and you get yourself in both a good headspace and good physical headspace, the losses, you're going to learn to deal with them a little bit, I think a little bit better from a stress standpoint. Because this is it's a tremendously stressful job. Yeah. So certainly would encourage more people to do things like that.
I totally agree. And I think just getting back in there and try another one, like forcing yourself. Absolutely. I mean, I tried one in, July to August, had a mediocre result, was pissed off about it, and then had to go try another case. It had a great result. And I was not any better of a lawyer in the second trial or any worse of a lawyer in the first trial. It's just they had different facts, different juries. And, if I had let the first one get me down and I chickened out and wouldn't try the second one.
Right. Or you would have taken probably a mediocre offer because you were a little gun shy.
Right.
And that's one of the things that...
Oh, they didn't give me that option on the second.
Yeah, I know. Yeah.
There was I didn't even have I would have taken a mediocre offer.
You and I have talked about, we've tried a lot of zero offer cases.
Yeah, that was, $50,000 offer and an amputation where the workers' comp would have gotten all of it. And zero in the client's pocket. No, that was easy. I can't claim bravery there.
Yeah. No doubt about it.
Okay, well, let's talk about, so trying cases during COVID. You actually tried cases when everything was shut down.
I did. I tried 3 cases during COVID, and I know you had tried one, and you and I had actually talked about when you were getting ready for trial, and I think, we kind of have a very similar experience. What was taken away from us during COVID was our freedom of movement, even in the courtroom. Judges made you stand at a podium, and you had to wear a mask and everything else. And so we really worked very, very, very hard at creating this medium that allowed the jury to still have an experience in the courtroom, but not have the same experience. Because, when we tried the cases, the jurors were spread out all over the gallery. They weren't connected. So it was a very, witnesses were in the jury box instead of on the witness stand. So we really had to work hard to create some type of atmosphere where, even though I wasn't able to have a big board and point on the board or have the witness get off the stand and explain something to somebody. So, we used a lot of visuals, TV monitors, PowerPoint, a lot of graphics. And one of the things that we really worked hard on was shortening the trial.
Okay.
Because I think that, people didn't want to just sit through that whole environment. They wanted to get the information that they needed to make a decision on the case, do it quickly, but it had to leave an impression. And so one of the things that we really started to work on was that our questions had a corresponding visual component in the courtroom.
Tell me, can you explain that?
Yeah. So, what we would do is we started to use a lot of yes/no matrix charts.
What's a yes/no matrix
chart?
So,
I'll give you an example. For, in a trucking case where you have certain criteria that obviously the company needs to follow to hire a safe driver. So normal pre-COVID, you would have your expert going up there and saying there has to be an application for employment, and then you'd show the application or lack thereof. Drug tests, road tests, driver orientation, the inquiries to previous employers, all these steps. We couldn't do that during COVID because you wouldn't be able to walk up and here's the file, show the jury what's not in it. So what we started to do was take all this information and condense it down into one slide that now, our expert or the witness, the safety director for the company or whomever it is, if you're on cross, you're just able to go through and now start asking, all right, is there an application for employment? No. Is there a drug test? No. And so now the question had a corresponding visual image that now left an indelible impression in the jury, like, oh, there is no application for employment. They didn't, do inquiries. And rather than having all of the documents, we have all the documents, but now rather than going through, I don't want to say the dog and pony show, but it was a dog and pony show it's quick hitting items and then these visual summaries of large volumes of information. It's become invaluable for us, and we use them in depositions now, even moving forward.
Yeah, you've been kind enough to share some of the stuff you've done on some depositions where it's just beautiful. I mean,
we work hard on it. We have a great in-house tech guy. His name's Chris Spence, and he is part of every case from day one, and he does all of our PowerPoint graphics in-house, and we've tested them too. That's the other thing. We didn't just kind of come up with, oh, let's do this, and we started testing these with data surveys and jury and focus groups, and they loved it. It was instead of having 20 minutes of a cross, it's 4 minutes of a cross.
Yeah, I think the other thing is that you ask all the questions. 20 minutes later, they don't remember the first things you asked about. You made these great points, but if they don't remember them, whereas when you have it in writing, even if they were like kind of zoning, because some jurors going to be zoning out at any given part of trial.
No
We're
doubt.
human. I mean,
no doubt. Yep.
We're going to be watching lectures today from very great speakers, and there will be points in time where we're going to be thinking about something else, or just because we're human beings.
Yeah.
But then they can go back to it.
Yep.
And it stays there and it reminds them.
And they see it.
Yeah.
And I think that was one of the biggest takeaways that we got from COVID was, look, let them see more things. And when I say see more things, not just documents.
Yeah.
Because they could be boring as hell, right? But let them see more things that we've created that move the needle and tell this, in our favor, and tell the story in the way that we want it. We just did it with, expert deps, past couple of weeks. Like, where this particular expert is, he has an opinion, and his opinion is, well, you shouldn't check the safety scores before you hire a motor carrier. And there's 11 industry sources on the other side that say you should. And so now we created a visual where on the left-hand side, it's these sources. On the right-hand side, it's just this guy. So now when you look at it, you're like, this guy kind of looks like he's full of shit.
Yeah, exactly.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
So what's your advice to people that want to start, if someone wants to start in figuring out how can I incorporate more visuals or more graphics into my practice? Because I think it's not just for the trials, it's for the depositions.
Absolutely. I think one of the things that encourage everybody to do is that when you're sitting down to prepare for your deposition, if there is a category of information, look at that category of information and can you now translate that into some visual image, whether it's a yes-no chart, whether it's a timeline, it could be a graph, a pie chart, whatever it may be. Can you take all that and can you create some type of image for all of that information? I'm a firm believer that the answer to that is usually yes, 100% of the time. There's not many cases where we're like, well, geez, there's no image. There's no image for this. There is, but you have to, you got to look at it. And so I think we get into a habit where we're just asking questions.
Yeah.
And I think one of the things that I would tell people is start, when you look at your depositions, think about trial.
Yeah.
And think about how am I going to create something that I'm going to be able to use moving forward. Putting it in summary judgment motions, that's one of the things that visuals that we're creating. Now we're filing proactive summary judgment motions, putting those visuals in there helps educate the court as well. And now the other thing is when the judge sees this in a summary judgment motion, he or she is far more inclined to now have no problem with it, in trial.
Exactly.
Because that was one of the, I certainly think that was one of the big pushes on the defense bar, why they wanted to change the federal rule on visuals, because it is effective, and that's how people learn. And I think they wanted to go back to the dark ages where they don't want people to see anything. They don't want people to look at anything.
And we forget, in law school with so much reading and listening to lectures, and we learn to learn that way, but most people don't. I mean, and even lawyers, not there's some very visual. I'm not a visual person naturally, like take notes and it's there, and that's how I make decisions. But I found that it's not my job to learn the case. It's my job to teach the case.
Right, absolutely.
And I need to
Well, you did
this
something brilliant, though. When you had that model, I remember you were working on it might have been the case during COVID. Man, I thought that was just genius.
Well, it wasn't supposed
genius.
to. We were trying to show, it was a case where someone ran a stop sign, but it wasn't just a stop sign. There was a stop ahead sign, there was an intersection ahead sign, and a junction sign. And the driver, and it was over half a mile of signs. So the driver said he blew through all of them. So we wanted to create a visual. And at the time, we didn't know about COVID. We were preparing for the case. So I wanted to show that this driver had many opportunities, clearly had to be distracted. We said he was playing with his phone. Yeah. And so we built like a 12-foot-long scale model of the scene.
It was awesome.
And then, had to scale, little 3D printed cars to run on there. And then, of course, we had to figure out COVID happened. How can we use that?
Right.
So we had to really work with the video people to practice. Like, how do we it's awesome. And it almost looked like an animation because we would pan through there. But I had to hire a professional camera crew.
Yep.
But the case was worth it. And then, follow the car along and you can see the little signs. But it really does present that visual. I'm really big about now. I'm trying to move from just the graphics to things that you can touch and hold. 3D printing. 3D printing's got so cheap.
Oh my gosh, it's fantastic. You're moving in the right direction because we're doing the same. If somebody can see it, if they could touch it, if they could feel it, they're far more likely to remember and have that imprinted in their memory, whatever it is. And so we're always like, all right, we're going to use PowerPoints. We're going to use our bodies as a visual as well. Models, especially on damages. If people can see, see and touch like where the broken bone is and the rods and the pins, man, it leaves such an impression on, on them, as opposed to maybe just a static image on a screen. We use a lot. I know, we've talked about this before, like we've used animations, but you got to be careful with animations, because sometimes they may show something, you may see something that when you show it to, focus group, they're looking at it in a completely different way. So you gotta be very careful with the animations, but just giving the jurors a kind of a visual experience in the courtroom, I think helps us tell the story, and also tell the story in the sequence and manner that we want it, that hopefully we'll be successful.
So now that we've pretty much come out of COVID, at least most of the country, hopefully has come out of COVID. And we're actually, the jurors are in the jury box together. You can move around the courtroom. You don't have a mask on.
Yep.
How have you incorporated what you learned in trying cases in the weird COVID environment to trying cases now where we're kind of closer to back to normal? Yeah,
I think, post-COVID, pre-COVID, I would never really contemplate or did it very infrequently, having witnesses zoom in.
Yeah.
And now it's commonplace. I mean, I actually think that jurors, it is the expectation, if the witness can't be in the courtroom, that they're going to just be zoomed in. And I think they get annoyed if it's just a static video, because the technology is so good and they're so used to seeing it, whether it was, on television, every talk show, they're zooming people in.
Yeah.
So I think that's one of the things that now, especially with our experts, we're like, look, we don't want to put you on video. If you can't come live for whatever reason, we're going to zoom you in at a particular time. And I think that's one of the things that has made our presentations a heck of a lot better, especially, expert wise. And one of the things that it has forced us to do is when you're going to zoom somebody into the courtroom, what you're not going to do? Have them testify for 3 hours or whatever. It is short, it is hitting, it's very focused. And then especially even with the Zoom, we've been able to incorporate visual images. So now you see, the witnesses zoomed in, but there's still a big screen in the courtroom that's showing the visual images. So that's one of the things that we've done and incorporated. And then now, from some of the lessons that we've learned during COVID and just jurors' attention spans, what they want to see, our trials are so much shorter. I mean, they really are. I mean, we work really hard at getting them down to giving them the information that they need to make the decision in our favor and nothing more.
Yep.
And trying not to waste their time, at all. And then finally, the other thing that I would say we've kind of taken from COVID and now are really hyper focused on in our cases is the sequencing of the case.
Okay. Tell me about that.
Yeah. So, just give you an example. Case that we tried last year. Normally, I would say, okay, well, we're going to put on, it was a trucking case, and I would say, all right, we're going to put on the safety director, whomever it is, or we're going to play the safety director's deposition clips. And so now what we've done is, instead of doing that, we have as our first witness whomever that person is going to be that's going to tell the story from the opening.
Yeah.
So now I've told the story in exactly how I want it. And so now I want my first witness to mimic what I've said in the opening. And so now whomever that witness is, utilizing all of these tools, the deposition video clips, whatever visual images we have, putting it into that frame and that sequence, so that, because that's when the jurors are going to be most attentive.
Right.
That first witness. And if you just put up a first witness and it's just a talking head, you've lost that critical opportunity to really now engage them and move the ball and move the needle towards a victory. So the sequencing is something we work really hard, really hard on figuring out, first witness, second witness, just like
last witness,
yeah, first witness, and then the other, it's going to sound crazy, but the witness after lunch, because juries are just like we are, we're most focused when we get to work in the morning, and then you get it back from lunch, and that's the witness that everybody is going to be paying attention to, not necessarily the witness at 4:00 in the afternoon when everybody's ready to doze off.
And sometimes when you have, like, say, the defense took a video of a witness that's not going to be so great for you, maybe put them on at 3:34 in the afternoon by video.
Exactly.
Maybe make that video a little longer before they get to the bad point.
Yeah.
Everyone's asleep by the time they get to it.
Every time I know, I totally agree. They always say, "Hey, do you mind if we take this witness out of order, put this video in?" I'm like, "Yeah, no problem. Let's put them on at 3:30 or 4:00.
Yeah.
And inevitably, that you look over, the jurors are like, not an off for that. So yeah, it's but those are some of the, I would say, some of the key takeaways that we have learned during COVID, and now making our trials a lot more streamlined, and the presentation of the evidence a lot more efficient.
Yeah, and one lesson I've learned on that is it's not that you're trying to do. I know I talked a lot to Joe Fried about this. He used to use the term speed trial, and he stopped that because you get this, like, you got to rush through it. You still have to take your time and give the information in small enough bites that the jury can get it. Give them time to absorb the material, to understand it. It's just you're not spending time on a bunch of extraneous stuff.
No question. I played basketball in high school and college, and John Wooden, my college coach was a big, huge John Wooden guy, and he would say, move quickly but not in a hurry.
Right.
And that was, something that left a really an impression on me, especially in our practice. Like, if you're moving quickly, you're moving efficiently, but if you're in a hurry, especially in a courtroom, you're just rushed.
Right.
And I think that's, I believe me, I'm a firm believer in what Joe's trying to do, and doing it in a more efficient manner. But I think you're right, like, not speeding. You're not speeding. You're just doing it more efficiently.
But you're also learning to, like, not make every possible argument.
Right.
Sometimes if the defense says something really stupid, just let it stay there. Trust the jury that they're going to understand that's stupid.
It's just stupid.
You don't have to cross-examine. Like, if you've got 10 things you can cross-examine the defense expert on, just do your top 3. That's strong. You don't need to do 7, 8, and 9.
No. And, half the time, we're doing it for ourselves, rather from the jury.
Or we don't trust that our 3 best are good enough, and so we got to put our other 7 arguments because, well, what if the other 3 didn't work?
Right. No question about it. I couldn't agree more. It's giving them, imagine if you were in the jury box, would you want to hear all that?
Exactly.
And the answer is no. One of the really fascinating things that we did was I made all of my lawyers sit through, be like focus group jurors for a case. And then they saw firsthand, they're like, "Oh my God, this is dreadfully boring. Like, we need to shorten this, clip that. We need a visual image here." And they start to see it, especially if you watch a video depth that you've taken of, like, a doctor, and it's the doctor and then 2 lawyers just talking. You're like, I may jump out of the window here in the courtroom because I can't take it anymore. I just can't take it anymore. So, those are some of the things that we've really been trying to work on, moving forward, learning from COVID.
Yep. Well, it's so good that we've been able to get something good out of something that was so horrible.
Yeah.
So when you're picking a jury now, do you ever have people that still show up with a mask on?
I do.
What do you think about those people?
So that's a great question, Michael, because, I'm trying cases pretty much all over Pennsylvania, and Pennsylvania is a really interesting state because, as James Carville once said, you got Philadelphia, Pittsburgh, and like Alabama in the middle, right? Yeah. So we have very, very, very liberal pockets. I mean, Philadelphia, I can't remember, the cases that we've picked in the last post-COVID, I don't think anybody shows up with a mask on, right? Same with Pittsburgh, out in Allegheny County. Although there are some, pockets of Allegheny that are different. But, you go pick a jury in Carbon County, which is, 98% Republican and very, very, very conservative. Nobody's wearing a mask. But if somebody comes in with a mask, now all of a sudden, you're like, what's going on here, right? And so it's a really interesting. You see those people turn on that person, right?
Yeah.
And that, okay, this is going to be, like in counties like that, you see the very, very, very clear line. But like I said, Philly, there's a few people maybe that still wear a mask, but it's predominantly not worried about. But in some of these other small rural counties, it is an issue, because that particular person, for whatever reason, still has this belief that they need to wear this mask inside in order to protect themselves from COVID. So
yeah, I struggle with it because, first of all, I have my own personal prejudice, which is like, why the
I know,
are you wearing a mask
I know,
now?
I know.
And, we've all had it by now. Come on, let's get on. Not forgetting that different people have different,
Sure.
physical conditions, people at home. But, my instinctive, that it makes me think of like the image I saw on Twitter the other day. It's like a guy is riding a motorcycle without a helmet and has a mask on outside.
Yeah.
Like, come on.
Yeah. No, I know.
Your risk assessment is not very good here, buddy.
Not at all.
Now, but part of that, there's someone that's really safety oriented. They're fearful, but are they going to be feeling like they're in danger the whole time? Are they going to be able to focus on the case and emote with someone else when they think I might die from being here next to all these people?
Sure.
And then just like I said, the group dynamic. Jerry is a group dynamic. If that person is more likely to advocate for me because they're a safety person, is everyone else going to say, that's one of those mask wearing liberals?
Yep.
I'm automatically and instinctively going to go against anything that they say.
It is so polarizing, and you're 100%
so
right.
I've been striking mask wearers.
Yeah.
I haven't said that publicly before, but I'm just kind of curious as to what other people thought about it.
I don't disagree at all, because I do think it's there's a few issues that are just in our culture right now that are so polarizing that it can totally distract from everything that you're doing in the courtroom, and that's one of them. Yeah. And I think that you're right to strike them. I have the same belief, because I want a neutral playing field.
Yep.
And I don't want, if there's 11 people in the box and one person wearing a mask, then that one person is going to be, they're going to go into deliberations, and that one person is going to be pushed to the side.
Yep.
And if that person is very on my side or on my client's side, these other 11 people are going to cannibalize that that person, and it's not going to go well. So I think you're right. I think now, when I look back, I think I have also struck every person that has had a mask on in the last year and a half.
Yeah, we had one surprise. She ended up being an alternate. She didn't wear a mask for jury selection, but when the trial started, she started wearing one every day.
Interesting.
But she was an alternate and didn't make it on there anyway.
That's very interesting. So, yeah.
Last thing, just you've talked a lot about graphics. Of course, this is almost like a radio show, a podcast. You can't see the graphics,
Right.
but we do have a website. Do you have any you'd be wanting to share that we could put
Absolutely.
up on the triallawyernation.com website? You can go to the episode page, see some examples, because I've seen them. You've done some incredible stuff.
Well,
I take them, I show them, like, look what he's doing. We all need to do this too. And I've got like Sonia and Mallory are so much better than I am at the graphics, but I have people that are so brilliant at graphics already.
Yeah.
But every time we see something really good, like some stuff you did, like, look, we can take this to another level. Look what he's doing. We could do that too. And I'd like, the listeners to be able to go in there and
absolutely.
see some of that.
Absolutely. Yeah. I'll share a couple of, PowerPoint presentations that we've done on visual aids, and I'll shoot it to you, and you can put it right up on the website.
Awesome. So that'll be on the episode page. So just get there, triallawyernation.com, find the Ed Ciarimboli episode, and we will have them there in the show notes.
Michael, thank you so much for having me on.
Thank
Really
you.
appreciate
I really enjoyed seeing it, and I'm glad we're going to be able to spend some time together here in Atlanta.
Absolutely.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive plaintiff lawyer only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.